Good morning, everyone, and welcome back to Coffee with Craig, where we talk about all things firearms, firearms policy, politics, culture, media, you name it. We're talking about it right here on Coffee with Craig. So please take a moment, like and share the program so that your friends can join in the conversation. Also, if you haven't already done so, please make sure you subscribe to our YouTube channel. Follow us on Facebook, Instagram, and Twitter. And in the case of Facebook and YouTube, make sure you hit that notification button. That way you'll be notified as soon as we go live, and you can participate in the live chat as the program is taking place. Also, please take a moment and visit FPCgear.com. That's FPCgear.com. It is the place to go to get all of your Pro 2A swag, t-shirts, coffee mugs, tank tops, something for yourself or something for the significant other. Folks, we got it all there. And the best part about it is every dollar that you spend goes right back into the fight for our right to keep and bear arms. So you can support the Second Amendment and you can look good doing it. That's FPCgear.com. All right, we have a big legal announcement here in the state of California. But I think, once again, it's something that I think that will impact folks on a national scale. So I wanted to have on the program FPC's Director of Legal Strategy, Mr. Adam Kraut, to share the big news. Mr. Kraut, how are we doing today?
Good. Good morning. How are you?
I'm doing excellent. So please tell us, what's the big news?
Sure. So, as many of you know, especially the Californians, you've been following our assault weapons case, Miller versus Becerra. And yesterday, Judge Benitez issued a decision in which he denied the defendant's motion to dismiss, which is awesome because that means we get to go forward on all the claims in our lawsuit.
And you know, the one of the worst things, the things that bugs me the most is when these things are actually approved, and it seems like it seemed to me, and once again, I'm not a legal expert, but it seems to me like disproportionately when it comes to the Second Amendment, it seems like these cases wind up getting thrown out. And to me, it's really important that we, at the very least, at the very minimum, get an opportunity to make a case before a judge.
Yeah, and it certainly, obviously, it depends on what the claims are, where they're brought, and a whole lot of things. In this particular instance, the state of California was saying that the plaintiffs did not have, one thing was that they didn't have standing to bring the claims, and standing is one of the very basic things you need in order to actually bring a lawsuit, so that you actually have an injury in fact that you can point to and say, hey, this does affect me. And as we've seen in numerous court decisions for a very long time, a person doesn't actually need to put themselves at risk of prosecution in order to assert standing. So you can challenge the pre-enforcement of something rather than expose yourself to all the criminal liability that would come with violating a statute before you walk into court and say, hey, by the way, this thing affects me negatively. It's unconstitutional.
Well, you know, that's an interesting fact that you make because, you know, a lot of people don't realize in a lot of these cases, it's like you have to actually be an injured party, meaning you have to be subjected to potential jail time, potential fines, penalties, criminal. I mean, in order to just challenge a law, it's hard to challenge a law just on its face.
Yeah, so I mean, when we're talking about challenging laws, there's two things. You have a facial challenge, which is attacking the statute or the law just on its face, saying under every application it's unconstitutional. There's no world in which that this actually is constitutional. And then you have as applied challenges that are specific to an individual circumstances, where they're saying as applied to me and my facts, this is unconstitutional. So here, obviously, you know, we're challenging it on its face, just saying that it's flat out unconstitutional, not just as applied to these individuals and in their particular circumstances, but as applied to everybody.
So what's next in this particular case, and what does kind of the timeline look like?
Uh, so, as you know, federal courts and their timelines can be all over the map. COVID hasn't helped things. So, earlier this year, it was either late February or very early March, there was a hearing scheduled for our motion for preliminary injunction. That ended up being canceled due to the uncertainty of everything. Now, My understanding is at the status conference yesterday, the judge did mention that he would be issuing an order for hearing on the preliminary injunction in the relatively near future, and I believe that that hearing will also occur within the next month, was my understanding of what was the conversation. So it seems like Judge Benitez is certainly interested in moving the ball forward on getting a hearing done and then issuing an order on the preliminary injunction itself.
Well, that is phenomenal, and it's also nice to know that we have a justice in this case who understands the Second Amendment, and applies it in a way in which I believe the founders would want to see it applied.
Yeah, I agree. I think as far as the judge we're in front of, we have a very excellent judge who has a great understanding of the issues before him, as we saw in his prior decisions relating to Second Amendment issues. So we're looking forward to our day in court for the preliminary injunction, and then hopefully after that, we'll be on our way to a summary judgment motion and a final decision from this court before almost certainly the government will appeal it to the Ninth Circuit. I don't see them taking an adverse decision, assuming that's what in fact occurs. I don't see them just letting that go.
Well, neither do I. And by the way, I think that's why a lot of our listeners, a lot of our viewers are, a lot of them are in California, a lot of them are in other states. But that's why it's important. These decisions are important because it does have an impact, because we know it's not going to just stay at the federal court here in the Ninth District, but eventually it's going to go to the Ninth Circuit, and eventually it's going to wind up, impacting people beyond just those of us here in the state of California. So anyway, do me a favor. Let folks know how they can follow the legal work of the Firearms Policy Coalition.
Yeah, absolutely. So if you go to firearmspolicy.org/legal, you'll see a feed of all the things that we're doing. We are constantly updating it with the briefs that we're filing, new complaints, stuff like that. Obviously, social media is another great way. So if you're not following Firearms Policy on Instagram or Twitter, or even Facebook, there's another mechanism for you to do it. I know on Twitter and Instagram, it's at Gun Policy. If you search Firearms Policy Coalition on Facebook, you'll be able to get tuned in as well.
Excellent, sir. Thank you so very much. Very much appreciate you. Appreciate all the work that you do. Thank you for coming on the program so last minute.
Hey, it's always a pleasure to join you. So let me know when you want me back on.
Will do. Ladies and gentlemen, Mr. Adam Kratt. All right, folks. Well, hey, that's going to be it for today's Coffee with Craig. We very much appreciate you guys tuning in. We appreciate you liking and sharing the program and telling your friends about the Firearms Policy Coalition. We are the home in the fight for civil rights. Got to use them or you're going to lose them. You guys take care.
If you like our videos, follow, subscribe, like, and share.